we'll share the names of the people who have the name, just the name, one name, whichever you pick. So this one I'll be picking randomly, so that I try and find out whether people are keen. Are we together? So at least for this, our guests, the bailiffs, and the ushers are exempted. Trial and oral advocacy is paying attention. So that now by paying attention, you're able to now zero down on what the other counsel shared, so that you're in a position to either rebut or support. So I'll be going randomly. You share the names of the people who have spoken before. And then now we will have the last gentleman wrapping that up as part of the experience. Tuko pamoja paka hapo? So there was a gentleman by the name Njogu. So Njogu, stand up so that they can see you. So you remember our rules. Don't mention Njogu's name. So Njogu, the task for you is very simple. Just give us the names of the people who have shared their experiences. And as you take the microphone, don't whisper the name.
Good morning, everyone.
Good morning.
I was not paying attention. But I can remember her name is Hafsa.
Uh-huh.
I can also remember the Riara guy. He was good. We mooted together.
Mm-hmm.
But cannot remember the name.
Mm-hmm.
But other than that, I will wish to maybe pass the mic to someone who thinks he was paying attention.
Feel free. Now that you've admitted, admissions under the Evidence Act. So feel free to nominate somebody you feel was paying attention.
I'll ask a volunteer. Oh.
Just check around.
Was there nobody paying attention?
Okay, now that you are paying attention to nobody paying attention, have you recalled him? Now that you are now paying attention, that nobody is paying attention. So from the two benches, with the exception of your colleagues or your students in the same institution, who else can you nominate?
I'll nominate the gentleman in the middle.
The gentleman in the? Sorry. Just feel free to walk around. It's easing the tension.
Must I stand up?
No. The honors is yours.
Okay, so could you kindly clarify the rules? Am I stating I was observant? Yes, kindly.
Okay,
Don't mistake
now that
me
you're
for that.
observant,
Yeah.
sir, what did you observe?
Let me see, the people who spoke and gave us the experiences. I can remember Hafsa. I can remember Ryan, who nominated Diego. I can remember Hamza. Yes. I can remember, okay, I think he's playing games with me. Yeah, I think he's playing games with me, but yeah, so I think I might pass.
So you've already mentioned three names.
3 names.
Yes.
So,
So maybe as you try and recall the last one, the first rule, at least if you can, at least everybody is observing. So if you can forget everything, the first rule was you stand up, or rather if you choose to sit, your name.
Oh, okay.
Yes.
My name is Ahadi Minor. I apologize. I feel like I am preaching because I'm not used to holding mics. So, so yeah, yes, Minor Ahadi is my name. Yeah.
Okay, thank you so much. So as you hold it, be very careful not to drop it off.
Oh, okay.
And then while at it, now you have to stand up. Identify one last volunteer who will now try and remember everybody's name, and now nominate the gentleman to wrap this session up for us.
Except bailiff.
Except bailiffs.
Yes.
You know,
So, wacha nikupe mwa Kenya. Wameka the first row after you, and the second one.
Except bailiffs. Nani anakaa kama anataka kuchaguliwa? Okay. Sijui mnataka kucheza rock paper scissors ama mko sawa? Sawa. Exception of the colleagues. Sawa. I'll just choose you.
Thank you very much, Maina. My name is Joseph Ogor from Egerton University, and I've been told to name everybody who has spoken. I'll start with Marcia Lodge, who talked about the experience she's had, and the other lady, Hafsha, if I got it right. Yeah. And then, of course, Maina and Mr. Mount Kenya. Yeah. And then at the back here, we also had Mr. Njenga. Yeah. Mr. Njogu.
Okay.
Yeah.
I see we have very many pastors coming up, baptizing people with new names. So anybody by the name Jenga? Yeah?
Oh, Njogu. Yeah, Njogu.
Okay.
Yeah, and then Yego as well.
Thank you so much, Joseph.
Yeah.
At least you are both observant and
Attentive.
attentive.
Yeah.
Okay, so now, the last bit of the rules, or rather the instruction, was identify a fellow gentleman who is a participant to wrap up this session so that they go ahead, share the experience, then we can now wrap it at that and formally begin our program for day 2.
Okay, at this juncture, it is an honor to welcome Mr. Wepukulu.
Mr.?
Wepukulu.
Okay.
Okay, thank you, Joseph. Greetings in the morning, learned and educated friends, or rather persons. As said before, my name goes by Frederick Wangila, or rather Wepukulu, as my surname. And it has been a pleasure participating in this Moot, whereby doing it, we can be able to shape the law as advocates in the making. And hope we heard the observance from the Parliament and as well as the ODPC, whereby they're gonna make better policies and better bills for them to be implemented to better our data privacy and data protection. I'm from Uma University. I'm a colleague to Njogu. So without much further ado, I will yield back the mic to you, sir. Thank you.
Thank you so much, Mr. Fred. So thank you so much, Mr. Pukulu, and everybody who's spoken before you. Now, I don't know whether we are all in. Is there anybody whose colleague is missing?
Yes, our colleague is not in actelic tristry.
Sorry?
This is our colleague, one of our participants.
Uh-huh.
Not in. He goes by actelic tristry.
His whereabouts accounted
He's coming.
Okay.
Yeah.
Anybody else? So now, at this juncture, ladies and gentlemen, we'll be starting off our schedule for the day. And before anything, I'll invite Madam Rispa Mambo to open the day with a word of prayer. Thank you so much.
Let's all believe and pray. Father, in the name of Jesus Christ, we pray this morning, Lord, that you're going to lead us through the whole of this day. Thank you for giving us the gift of life, Lord. and helping us to successfully finish the Moot. Oh Lord, we pray for a successful day, Lord, and let the sessions be cooperative, oh Lord. Thank you for the chance to serve the nation, Lord, and thank you even for our students, Lord. As they prepare to face the world, Lord, may you establish their plans, oh Lord. Thank you for this day, for anything that we're going to take, Lord. I'll drink, my Father, bless it. We pray this, believing and trusting in Jesus' holy name. Amen.
Thank you so much for that. So at this point in time, ladies and gentlemen, I would like to request all of us to be upstanding for our national anthem. Thank you. We may resume our seats. So, as it has been the norm, I'll start with the housekeeping rules. Then I'll go straight to the announcements for the day. So after the announcements for the day, I'll be inviting Mr. Simon, who has been the Moot coordinator and my co-MC, to be able to share the remarks about yesterday's sessions. Thereafter, we'll be able to now release or announce, let me not say release, we'll be able to now announce the results of the semi-final rounds, so that at that particular point in time, for the teams that will have made it to the finals, they'll be given some time to prepare for the SEM, so that we all then converge after that. So in between, we can be taking a group photo, and if the coffee will already be ready, we'll be taking the break, so that immediately after that, we'll be all converging here, so that we introduce the judges, then go straight to the final rounds. So as part of housekeeping, for those of you who are joining us today, when it comes to the washrooms, from where we are, there is the judges' parking. So there's a gate. We have markings around all labeled washrooms. So you go, you turn to your right after the last gate, just before the security checks. So you'll be able to see the block at the corner. When it comes to the courts that we'll be using today, after the very rigorous rounds, we'll just be left with court 1 for purposes of announcements and the finals. Now, when it comes to the reimbursement for the transport and the relevant expenditures that have been taken in by the teams, that will be done once we close the sessions. So the relevant team leads kindly coordinate with either Simon or Nicole for further guidance. Then, being the final day, I would just like to thank you for allow me to welcome Simeon to give remarks and a commentary of what transpired yesterday during the quarterfinal and the semi-final rounds. Thank you.
Thank you so much, Eugene. Good morning, everyone. Good morning once again. I like the tension in the room. I've been there before. But we'll start first of all with a brief comment on what happened yesterday. I'll just be giving brief comments, and then Eugene will announce the teams for the finals, and then I'll come back to issue a few guidelines on how we are going to do it, because we have a very excellent bench that is going to be judging the finals. So yesterday we had rigorous rounds, as Eugene has mentioned. We had the quarter-final rounds for the competition. We had the semi-final rounds. And just to note, before the competition started for the oral rounds, we had written submissions from 16 teams who submitted their written submissions. And from that, we were able to pick 8 teams that now proceeded to the oral rounds. So a round of applause to everyone who was able to make it to the oral rounds. That in itself was a competition, and you're privileged, and we congratulate you for making it that far. We now proceeded to the quarterfinals, where we had 4 courtrooms. Each courtroom had 2 judges from a pool of experts on data protection issues, from members of the Office of the Data Protection Commissioner, civil society, and members of the Law Society of Kenya, who helped us adjudge the moots. And a point to note, they were even able to make comments and say that you're better. You guys are better than lawyers. Let me not be quoted, but they said you're better than lawyers out here masquerading to be knowing about data protection. So a round of applause again to you guys. Yes, so after the quarterfinals, we had 2 courtrooms where we are having 4 teams that proceeded to the semifinals. In all the rounds, to determine who was the appellant and the respondent, we used raffles for the teams to be able to pick who will be appearing on which side. And finally, we had from the semifinals, we're going to be having 2 teams now proceeding to the final rounds of the competition. Just to note, mooting is not just about winning, and I'm not saying that to comfort you. I have done internal moots in my school. I have done national moot. I've also been privileged to do an international moot. And the kind of knowledge you build, the kind of advocacy skills you're able to build as a young professional growing, you're definitely standing out than everyone else who just focuses on classwork. You're doing something extra. You have a bit of work experience. You're dealing with the law as it stands, not hypothetical provisions. You're actually dealing with the law, and that also is to congratulate you. You have better knowledge of the law on data protection, and there are so many opportunities out here that with having participated in this mode, you can be able to take part in those opportunities and be able to contribute to the discourse further. So a big congratulations to everyone for the spirited fight. Just a comment to note from the judges yesterday, only one, that when you're pressured by the bench, it is okay to concede and say you are allowed to be guided by the court so that you don't take a lot of time on the back and forth with the bench. But again, the questions asked by the bench are to guide you and not to veer you off your submissions, just to guide you to proceeding to your next submissions. So be alive to that, not only in the finals, but also subsequent competitions that we are going to be taking part in. Thank you so much. I'll come back briefly after Eugene has announced the finals, just to give a few guidelines on how we are going to be doing the finals. Asante sana.
Before announcement of the results, makofi is in a didimia. Could you please just give Simeon a round of applause, a proper one? It's always good to clap until it gets to your moment to celebrate, right? So thank you so much for the words of both wisdom, knowledge, and additionally encouragement to the participants. So mine will be to just go straight to announcing the semi-final results. Let me not say release. So semi-final 1 was between team number 363587 against team number 286911. So this was scheduled, or it was taking place in court number 1, and the scores are as follows. So team 363587 managed an average score of 79.75. Whereas team 286911 managed an average score of 74.25. Ladies and gentlemen, that means that our first entrant into the final rounds of this inaugural National Data Protection Moot Court competition will be team number 363587. Makofi kwao. The other semi-final pitted team number 955362 as against team number 832415. So this was happening at court number 2, and the average scores are as follows. So team number 955362 managed an average score of 72.25. Whereas team number 832415 managed an average score of 73.75. So ladies and gentlemen, the team joining team number 363587 in the final round of this particular moot court competition will be team number 832415. So allow me, ladies and gentlemen, to request you for a special round of applause to team number 363587 and team number 832415. Makofi kwao. So at this point in time, before I come in to introduce our judge for the finals, I will cede the floor again to Simon to communicate the guidelines of the competition moving forward. Thank you so much.
Thank you, Eugene, and once again, congratulations to the team proceeding to the final rounds. Now, for the final rounds, as Eugene is going to introduce, we're going to be a bench of 3 judges. We're also going to be having a team of 4 bailiffs, so you can organize the extra seat before I finish. A team of 4 bailiffs. Just a few ground rules for the teams. We are going to be having 35 minutes per team to be able to argue your case. You're going to be asked questions within the rounds. Just to also ask us to maintain professionalism, the couple of rules, the normal rules for court. Once the bench comes in, we are all going to arise. Once they are seated, we are going to be seated. The bailiffs are going to announce the case, and then immediately after, we're going to be having the lead counsel. The bench is going to ask the lead counsels for each team to make appearances. So making an appearance, you're going to be saying you're the lead counsel, your name, of the time allocated, how you've distributed it as a team, and then afterwards, the respondent lead counsel is going to come in as well and make appearances, and then after, the appellant is going to begin making their case. That is all. I wish the finalists all the best. Thank you.
So at this point, before I make or rather introduce our judges for the day, allow me to still ask Simon to stay back for purposes of conducting raffles for the finalists. So I'll kindly request the representative from team number 363-587 getting to where they are has not been an easy contest, and you can all bear as witness based on the experiences you've shared. So I will go straight. Thank you. You can resume your seats. So just to add up on what Simeon shared, after I introduce I take us through the bio of our judges for the day, we'll request both teams to take for the day. We'll request both teams to take around 5 minutes to prepare so that they resume and take their seats at the front bench. So that will be done with the assistance of our able ushers and the bailiffs, so that now, immediately they are ready, we will be able to welcome our judges for purposes of starting off the final. So, allow me to congratulate the finalists as I go straight to reading out the bios of our judges for the day. So, ladies and gentlemen, our first judge, remember there are 3. So the first judge is Mushimi Mbaka. So Mushimi Mbaka was admitted as an advocate in the year 1989. And he's had a span of advocacy and litigation in a number of institutions, both civil society, private practice, and currently now in government. So he started off as an advocate at Kituo cha Sheria, where he pioneered in a lot of public interest litigation. Thereafter, he was enrolled as a litigation associate in a private law firm and proceeded to set up his own law firm, where he grew and scholarly interests. He is a columnist in a number of weekly newspapers, besides being a publisher and an editor of The Lawyer, which is a private monthly magazine. So when it comes to the official magazine of the Law Society of Kenya, he's also an editor, and he also doubles up as an editor for the East African Lawyers official magazine. So with regards to experience, he has a wide breadth of experience in civil, commercial, and criminal litigation in courts, tribunals, in addition to being, or rather, specializing in arbitration and lots of commercial work. He tends to have a bias or keen interest when it comes to energy law, specifically electricity transmission. So let us all appreciate our first judge of the day, Mushimi Mbaka. Ladies and gentlemen, our second judge for the day is Ms. Nancy Karanu. So Ms. Nancy Karanu is an advocate of the High Court of Kenya with 18 years post-admission experience in private practice. So she's the founding partner at Karanu Kanai and Company Advocates, where she has led a successful legal practice since 2016. Prior to this, she practiced at Muriu Mungai and Company Advocates, where she rose to the position of a partner. She is a renowned litigator, a data protection specialist, and worth mentioning at this point is Nancy Karanu heads the firm's litigation and dispute resolution practice, where she has extensive experience in commercial litigation, constitutional law, employment and labor disputes, administrative appeals, succession law, data protection law, and intellectual property litigation. She is also both a qualified arbitrator and mediator, and in addition to her practice, she provides expert legal training, which is tailored to meet the specific needs of her clients and actively contributes to the development of legal excellence through mentorship and adjudication. A round of applause for our second judge, Ms. Nancy Karanu. And our final judge is Ms. Bridget Ndong. So Ms. Bridget Ndong is equally an advocate of the High Court of Kenya and in information technology and telecommunication law from the University of Strathclyde in Scotland, as well as a certificate in European Union General Data Protection Regulations from the International Board for Information Technology Governance. With regards to qualifications, she is an International Telecommunications Union Artificial Intelligence Governance Trainee, a Certified Information Privacy Professional, Europe, and finally, a privacy technology. She's also a professional mediator, a member of the International Association of Privacy Professionals, and an ardent member of the Law Society of Kenya. So let us give a round of applause for Ms. Bridget Ndong. So at this point, I would like to thank you for being attentive and supporting us all through. So I would first of all request our finalists to resume their seats, the first bench. So team number 363, 587, together with team number 832, 4 and 5. Let's all resume our seats. I request all of us to be upstanding.
You may sit. Court is in session in the Republic of Kenya at the High Court. The case between Patrick Osogo versus the Republic of Kenya and Kenya Judiciary Data Systems Authority. Before, Honorable Nancy Karanu, Honorable Bridget Ndo, presided by Honorable Justice Mshimi Mbaka. I now hand over to the presiding judge.
Good morning. I'm calling the session to order. On my immediate left is my fellow judge, Nancy Karanu, and on my immediate right is my sister judge, Bridget Dong. We are here to learn, and I would want you to do it in an easy manner and don't feel under any pressure. And learning is a two-way process. We will be learning from your latest experience as scholars, and we hope you can learn something from us as experienced practitioners of the law. So we will start with the lead counsel for the appellant, who will introduce the co-counsel and the issues. Then we will get an introduction from the respondent's lead counsel. We also introduce the co-counsel and your issues. Each side will have about that 5 minutes. The judges will have a right to interject in the course of the proceedings. Thank you. Let's get started.
Greetings, honorable members of the bench. May it please this honorable court. For the purpose of record, I am Counsel Kenodia Judy, the lead counsel for the appellant. I am accompanied by my co-counsel, Jacqueline Achieng, and our research counsel, Nkadha Kiremi. Of the 35 minutes granted to us by this honorable court, I'll be using 16 minutes to deliberate on issue A, issue B, and issue C, while my co-counsel, Jacqueline Achieng, will use 16 minutes to deliberate on issue D, E, and F. We reserve 3 minutes for rebuttals. Thank you, honorable members of the bench.
Okay, thank you. counsel for the respondent. Read counsel.
Good morning, honorable judges. My name is Kamundia Gitahi, lead counsel for the respondents in this case. I'm accompanied by my co-counsel Hafsa Yusuf on my near end, and our researcher Avni Anyango. I shall be taking a maximum of 20 minutes to take the court through issues D and E, as we have framed them in our submissions on the criminal issues, as well as give an opening statement, while Hafsa shall take the court in defense of the respondent's case in 15 minutes through issues B, C, and E, as B, C, and F, sorry, as we have framed them in our submissions. Thank you. Okay. And we are team code N, sorry, it's, forget at times, my apologies, 363587.
Okay.
Yes.
So for the record, the appellant is 832,415. Is that correct? Okay, thank you. And the respondent is 363587. Thank you. Okay, counsel for the appellant, you have the floor.
My ladies, my lordship, I begin with submitting on issue A, where the appellant submit that the collection, the storage, and the use of the petitioner's data via registration in the National Biometric Identification System without a duly conducted and published data protection impact violated Article 31 of the Constitution of Kenya, Section 25, Section 25 on the principles of data protection, Section 31 on the requirements for mandatory DPIA, and Section 41, which places a statutory duty on data controllers and processors to adhere to the rules established by the Data Protection Act. Honorable members of the bench, I begin by acknowledging the backbone of data protection in Kenya, which is Article 31 of the Constitution of Kenya. It guarantees upon every citizen a right to privacy. And Section 31C specifically requires that information shall not be unnecessarily revealed or acquired. Honorable members of the bench, in fulfillment of this, Section 25 establishes a principle of lawfulness, which requires that data is collected and processed in a lawful manner. Honorable members of the bench, there is a special requirement to ensure that lawfulness has been adhered to for sensitive data under Section 31 of the Data Protection Act. This Section 31 of the Data Protection Act mandates a mandatory data protection impact assessment before the processing of sensitive data that poses a high risk to the data subject's data. On the definition of sensitive data, honorable members of the bench, I rely on Section 2 of the Data Protection Act, which establishes that sensitive data is any data that reveals a person's race, a person's ethnic origin, biometric and personal data to include fingerprints and facial recognition, honorable members of the bench. And in Republic versus the Chief Magistrate at Milimani Court, the High Court established that sensitive data requires the highest level of protection. Honorable members of the bench, I will turn this court I urge this court to be guided by the decision in Kenya Union of Journalists versus the Kenya Broadcasting Corporation, where under paragraph 21, the High Court established that the right to privacy is not aspirational, It is a constitutional guarantee that requires protection. It further establishes that entities that deploy intrusive collection of data, such as facial recognition, such as fingerprints, such as honorable members of the bench, I request for the pardon of this court. I did not include that decision in my submission. However, through the research, council came across that significant rule. Honorable members of the bench, that decision established that technologies that deploy the collection of sensitive data, such as fingerprints, facial recognition, iris scans, must adhere to the mandatory requirement of conducting a DPIA before the processing of data. Honorable members of the bench, I guide this court to paragraph 9 of our fact sheet, which established that Mr. Patrick Osogo data was collected via registration in the National Biometric Identification System. And this system, as per paragraph 9, included the collection of intrusive data such as fingerprints, facial recognition, biometrics, and personal data. This is data that poses a high risk to the data subject and requires the highest level of protection. Thus, a mandatory data protection impact assessment ought to have been carried out. In conclusion, honorable members of the bench, we assert that the collection, storage, and use of the petitioner's data via the National Biometric Identification System was a violation of Article 31 of the Constitution of Kenya, that is the right to privacy, the principle of lawfulness under Section 25 of the Data Protection Act, and the mandatory requirement of a data protection impact assessment provided by Section 31, and violation of the statutory duty mandated by Section 41 of the Data Protection Act upon data controllers and data processors. If it pleases this honorable court, I'll proceed to issue B, where the appellants assert that the use of data derived from the National Biometric Identification System in the operation of the Kenya Redizivium Assessment Tool without the petitioner's consent amounted to violation of his right to privacy. Honorable members of the bench, as irrefutably established, Article 31 of the Constitution establishes the right to privacy, which includes the right not to have your information unnecessarily acquired unless you have consented to it. Honorable members of the bench, before the processing of data, before any process of data, there are two requirements, there are two preliminary requirements. That is a duty to notify the data subject, and B, a duty to notify the data subject as established by Section 29 of the Data Protection Act, and secondly, to obtain the consent of the data subject. Honorable members of the bench, I rely on Section 29 of the Data Protection Act, which establishes the duty to notify, which obliges data controllers and data processors to notify a data subject of, one, their rights under Section 26 of the Data Protection Act. That includes their right to give or not to give consent, and their right to withdraw their consent at any point of the data processing. Secondly, the fact that their data is being collected, and the fact that, and how their data, for the purpose for which their data is going to be used. Thirdly, it requires a duty to notify the data subject of the fact that their data is going to be shared with a third party, and the risk involved, and the safeguards that have been put in place to ensure the secure transmission, if any. Further, Section 30 of the Data Protection Act requires that after you have already notified the data subject of their rights, of the fact that their data is being collected, of how it's going to be used, of whether you're going to share it with a third party, you ensure that you obtain their consent before you begin the processing. And honorable members of the bench, I rely in Republic versus Tools for Humanity Corporation, where it was established that informed consent meant that the data subject was fully aware of what they were consenting to. And this includes what data you are meaning to collect and how you are going to use it, and how it's going to be stored and used. Honorable members of the bench, as illustrated by the fact sheet, paragraph 9, Mr. Patrick Osogo had his data collected via registration in the National Biometric Identification System without being notified of his rights under Section 26 of the Data Protection Act, nor being notified that his data was going to be shared with the KRAT system and used to determine his proceeding. Thus, we conclude and positively assert that the use of the data collected via registration in the National Biometric Identification System and the subsequent use of it by the KRAT system without Mr. Patrick Osogo's consent amounted to violation of his right to privacy. My ladies, my lord, I'll proceed to issue C, which is the last issue I'll be handling. And on these honorable members of the bench, we assert that the sole reliance on KRAT algorithmic assessments, whose internal logic and methodology remain undisclosed, violated the petitioner's right to equality before the law and his right to a fair trial. Honorable members of the bench, Article 27 of the Constitution guarantees every citizen of a right to equality before the law. And Article 27(4) specifically includes the right not to be directly or indirectly discriminated based on socioeconomic grounds. Honorable members of the bench, in Geoffrey Mwangi Kamande versus Republic, the High Court established that denying a person bail based on irrelevant facts or unfair grounds amounted to discrimination, contrary to Section 27 of the Constitution of Kenya. Honorable members of the bench, in the present case, the judiciary relied substantially on the results by KRAT system to determine the bail and sentencing of the petitioner. He was not at any point given access to the information held by the KRAT system, nor given an opportunity to challenge it or question the results. That these amounted to discrimination. The KRAT system, sorry, my lords, the KRAT system relied on socioeconomic grounds such as the level of education, such as the neighborhood, the poor neighborhood that socioeconomic grounds such as the level of education of the petitioner and the neighborhood of the petitioner, substantially discriminating against him on an irrelevant fact. Honorable members of the bench, on the right to a fair trial, Article 52 of the Constitution of Kenya guarantees a right to a fair trial, which includes the right to have full disclosure of any material that is going to be relied on during a proceeding. Honorable members of the bench, in Muigai versus Republic, 2023, the court established that full disclosure included, yes?
The cases, please draw the attention of the court to the number on your list of authorities. Okay. As you cite, thank you.
That was on page 6 of my submission. Page 6.
Okay.
The case Muigai versus Republic, 2023.
It's Okay, proceed.
whereby the court established that the right to fair trial includes the full disclosure on materials that are going to be relied on and an opportunity to interrogate it. Honorable members of the bench, in the present matter, as per paragraph 8 of the fact sheet, the intent of the KRAT system remained undisclosed to the public and to the defendant. He was not illustrated further by the fact sheet. He was not given an opportunity to question the outcome of the KRAT, nor the internal working of the KRAT, substantially violating his right to a fair trial. And with that, honorable members of the bench, if it pleases the court, I wish to cede the floor for counsel.
Counsel, before you take your seat, my sisters, my fellow judges may wish to clarify one or two issues. Okay, we'll start with my sister, Bridget Long.
Thank you, presiding judge. One question, counsel.
Yes, my lady.
As an appellant, you wish to bring to this court for consideration a decision of the magistrate, right? So is it an appeal on the facts of the criminal case, or you're bringing to this court a constitutional question? And in that case, then at what point does the judicial independence cross over from independence and to accountability? Thank you.
My lady, on the first limb of the question you've asked, this petition before this honorable court, no, it's not a criminal appeal. We are before this court to request for a review of the process that was used by the trial magistrate in coming up with the decision that violates, in coming up with the decision and reviewing whether it violated the constitutional rights of the petitioner. And we acknowledge that this honorable court has judicial review jurisdiction as mandated by Article 165 to 165.6 and 165.6 and sub-article 6 and 7. On the second limb, I request for the pardon. I did not understand that.
I think by answering the first one, you've answered the second. Thank you.
Thank you, counsel. You've submitted extensively on the issue of consent. I need a clarification from your end on how that consent is obtained.
Thank you, my lady. For consent to be obtained, as was established in Republic versus Tools for Humanity, fully knows of the process that they are consenting to. And consent is obtained by firing from the data subject. As per section 28 of the Data Protection Act, data has to be obtained directly from the data. And seeing that my time is up, I request for
Maybe just a question. Is it written or not written?
It's written.
Okay. Thank you. Thank you, counsel, for a job well done. I think you can get your co-counsel now to proceed.
Thank you.
And Siunge Trende, please, this is a court of record, so give us your name in full and clearly. Thank you.
If it may please this honorable court, for the purpose of records, Jacqueline Achieng, I'll be appearing as the second counsel for the appellant. And if it may please you, we as the on issue D, I'll begin on issue D, and we submit that the applicants, we submit that the interlinkage of NBIS data with KRAT and the subsequent use of the socio-economic data and the biometric data without transparency, accountability, or human oversight violates the appellant's rights to human dignity and fair administrative actions under Articles 28 and 47 of the Constitution of Kenya. And on this honorable bench, I'd like to address this in two limbs. First, on human dignity, and second, on the right to a fair administrative action. Article 28 of the Constitution of Kenya guarantees every person the right to human dignity and that the inherent dignity to be protected and respected. Additionally, Article 19.2 of the Constitution lays the foundation and says...
But I'm asking whether it is appearing on the list. You supplying the court with a list of authorities,
yeah,
which you are relying on. So if it is on that list you mention and you say it's number this on the list, if it is, yeah, that's what I'm saying. Thank you. Proceed.
The High Court in paragraph 41 held that human dignity is a fundamental principle that almost all other rights in the Bill of Rights are informed by. And additionally, the court held that Section 25 of the Data Protection Act requires that data be processed in a manner that is transparent and accountable, and that the data subject be held as moral agents who have a sense of inherent worth. To continue, honorable members of the bench, we see that in this case, in the present dispute, the collection, storage, and also the use of the appellant's data was not done to concur with the human dignity, in that it was done without transparency and accountability. The appellant's data was collected, yeah, and that he was considered, in this case Patrick Osogo, his input was not considered to be legitimate. He wasn't told of how his data was going to be used other than at the point of identification of which it was collected by the NBIS. And in this way, we see that his input not being regarded as legitimate diminishes his dignity. On the issue of fair administrative action, Article 47(1) of the Constitution guarantees every person the right to a fair administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. Additionally, Section 4 of the Fair Administrative Actions Act requires that a prior notification is given, a reason for an administrative action is given, and an opportunity is also granted to the person where an administrative decision is being made. Section 6 of the same act further says that where an administrative body has made a decision, they ought to give all the relevant information regarding that process. And Regulation 22 of the General Data Protection Rules also requires that the data subject to have a right not to be subjected to automated decision making. And on this, honorable members of the bench, in paragraph 36, the case Katiba Institute versus President's Delivery Unit, it's in the list of cases. The court held that the collection of the data from the Huduma number system without clarity was going to be stored, used, and its subsequent use did not amount to the standards of transparency and accountability that ought to be achieved by administrative bodies when handling data from data subjects. And in this way, the court further stated that administrative bodies, while handling matters regarding data, should not do it opaquely. The the aggrieved persons should be made to question and understand the decisions that they make. Applying this to the facts, honorable members of the bench, we see that in the present case, the trial magistrate did not really interrogate the underlying analysis of the KRAT, or rather assessing its effect of fairness onto the applicant. So we see that in paragraph 3 of the fact sheet, the internal methodology and the internal methodology of the KRAT was not disclosed. So, So in the present case, and in paragraph 3, we see that the was not disclosed. So in this way, we see that the interlinkage of NBIS and KRAT in the absence of transparency and accountability meaningfully violated the rights of the appellant to a fair administrative action. Honorable members of the bench, on issue E, the applicants submit, just a moment, that the respondents' continued reliance on the data from NBIS for the algorithmic processing and interoperability purposes, despite a prior data protection impact assessment required, constitutes contempt of court, and that are ultra-vires actions. The Magistrates Act in section 10, subsection 3, provides that the willful disobedience of any judgment, direction, decree, order, or any other directions of the court amounts to contempt of court. And in paragraph 40, the case of Shima's Plaza Limited versus National Bank of Kenya, it is in the list of authorities. And the Court of Appeal, in this case, in paragraph 81, stated that that every person has the absolute and unqualified duty. If I may proceed. The Court of Appeal, in this case, held that it was an absolute and unqualified duty of every person against whom a court of competent jurisdiction has given an order to obey it unless and until that order is set aside. And the uncompromising character of this is that it applies even where the affected person considers the order to be wholly void or irregular. So therefore, we see that earlier on, the court issued an order of mandamus, requiring the respondents to carry out a mandatory data protection impact assessment. So in this way, really, the respondents really never took this into action. So can we really assume that this was an administrative oversight? I mean, this was a willful disobedience of the court's order. And we all know that it is for the due administration of justice, compliance is essential for the rule of law, and that our courts, and that for the good order, that our courts upheld their dignity at all times. So in this way, we submit that the continued reliance on the NBIS without a duly processed DPIA amounts to contempt of court. On issue F, guided should apply itself and be concerned with the process leading to the decision. And it should apply itself to the question as to how was this process reached through? And was the persons who were affected heard before the decision was made? And further requirements were established in Pastoli versus Kabale District Local Government Canal, paragraph 44, appears in the list of authorities. It was held that the applicant has to show that the decision was tainted by illegality, irrationality, and procedural impropriety. And in this way, honorable members of the bench, we see that a mandatory process was breached, which amounted to illegality. Section 35(1) of the Data Protection Act requires that a data subject be informed of, a data subject be provided, like where an automated decision making is made, the data subject should be informed, and also they should express their views and contest their decision. We see that, this section also includes profiling where legal effects amount to the decision made. In this case, we see that KRAT classified Patrick Osogo as a high risk person. So in this way, an automated decision was made by KRAT in terms of profiling, and the appellant in this case was not given an opportunity to express themselves or contest the decision. This is seen in paragraph 12 of the fact sheet. Also, honorable members of the bench, this process was also vitiated by procedural impropriety, in that the applicant was not accorded the opportunity to challenge the outcome of the algorithm and also to request the intervention of the trial magistrate. The same is also seen in paragraph 12 of the fact sheet. So, I mean, rules of natural justice are really the bare minimum standards that the common law imposes on our body acting judicially. So, in this way, we see that the appellant wasn't granted an opportunity to be heard or contest the decisions of the trial magistrate. Therefore, this honorable court should grant an order of certiorari and quash all the decisions and actions that were informed by the KRAT in making the bail and sentencing outcomes. And we pray to this honorable court that it makes a declaration that the interlinkage of NBIS and KRAT were contemptuous and that they are unlawful, and also that it grants an order of certiorari to quash all the decisions and actions that were relied or were informed by KRAT. And also it awards a constitutional damage to the appellant and any further relief that it may deem fit.
Okay, thank you. Is that all?
Yeah.
Yes, my colleagues who, it's okay. Yeah, please.
Thank you, presiding judge. I'd like to refer you back to the authority you've cited, Shimas Plaza Limited versus National Bank of Kenya Limited. That's it's an authority of which court?
Shimas, a minute, let me check. Court of Appeal.
The Court of Appeal.
Yeah.
And the Court of Appeal stated that every person against whom a court of competent jurisdiction has issued an order to obey it. That's what you said.
Yeah.
And the order that was issued as regards the National Biometric Identification System was issued to the Ministry of Interior, the National Administration. So on what basis was the magistrate court bound by that order? One, and then secondly, you've also cited Section 10.3 of the Magistrates Act. Are you alluding that the Magistrates Court was in contempt of court? And which court?
Thank you for your question. First, I'd like to answer the second one, then you'll pardon the first one. Okay, on the first one, the Magistrates Court wasn't in contempt. The respondents, they were in contempt of court. We have two respondents, the Republic of Kenya and the Kenya Judiciary Data Systems Authority. And in this case, in paragraph 3, the Ministry of Interior was working was the one who launched the NBIS system. So it was directed to conduct a DPIA before further processing of the data that was collected. So its failure to do this, since it was an order given by the court, amounted to contempt.
Contempt by who exactly? Is it the magistrate's court or the ministry? And is the ministry a party?
Will you please clarify more?
You have stated that the magistrate's court was in contempt, and you have cited the parties as the Republic versus the Kenya Judiciary Data Systems Authority. However, the order referring to the National Biometric Identification System was issued to the Ministry of Interior. So who was in contempt? Is it the magistrate's court in relying on the data in this system, or it is the Ministry of Interior for processing, if any?
Oh, thank you. The one was in contempt of court with the Ministry of Interior for failing to obey the order of, for failing to conduct a DPIA, which was required for further processing. It disobeyed the order that required it to conduct a DPIA. Yeah.
Not clarification. If it's a ministry that was in contempt, is this court then the right forum to consider the issue of contempt of court, or is it the court that issued the order?
Thank you for the question. So since the ministry was in contempt, hereby the appellant considers the process which was informed by the NBIS, which was also unlawful in that there wasn't a DPIA, was used by the trial magistrate. So this, I ask for additional time for this honorable. So, where was I? Anyway.
It's okay because of time. I think we can go to my fellow judge. Some things you would wish to clarify. And thank you.
Thank you, Counsel. You did submit on the Fair Administration Act.
Yeah.
And specifically Section 4, where you stated there was a decision that had been made.
Yeah.
So the question I'm asking you is, maybe just clarify what decision was this? And the relevance of Section 4 to this case.
Thank you. So, Section 4 requires a reason by the administrative body. And in this case, the reason required for is that regarding the bail and sentencing outcome. Am I answering your question?
Is that the decision then you are referring to in your submissions?
Pardon, please.
Because you stated that Section 4 mandates prior notification, justification for administrative decisions.
Yeah.
So what decision was this? That's what I'm asking.
Okay. The decision, first of all, what the appellants were seeking was the bail and sentencing outcome, which they found inconsiderate. So the appellants are seeking a justification for why such reasons were made, such inconsiderate sentencing and bail outcomes were reached at.
Thank you.
Yeah.
Time is up. wish to give you just a little time, how much time will you require? And then we will extend the same right to the respondents.
Time for rebuttals.
Yes.
We request this court to give us 3 minutes for rebuttals. Thank you. I'd like to cede the floor to my co-counsels.
May it please this honorable court, as I introduced myself earlier, my name is Kamundia Gitahi, and I shall be giving my submissions on what we see as the more criminal-focused issues in this case, which more specifically would be issues D and E, as we have put them in our memorials. Should I proceed?
Let's do some housekeeping. We want to get the score sheets. Just give us a minute. So thank you. You can proceed.
May it please this honorable court, as I introduced myself earlier, my name is Kamundia Gitahi, and I shall be answering on behalf of the respondents on what we see as the more criminal-focused issues of this case, which would be issues D and E, which focus on the Kenya Recidivism Assessment Tool, whereby I shall be proving to this court that there was no violations of Articles 27, Articles 50, neither Articles 47 or Articles 28 of the Constitution, in regards to the use of the KRAT in the sentencing or even bail assessment of the appellant for several reasons, but in summary would be number one, the assessment criteria used by this tool are used already as part of criminal procedure. The assessment that is of socioeconomic status as set out in the Criminal Procedure Code. That is why, for example, we have probation reports, pre-sentencing reports that go into looking at the character of an individual before they are sentenced. We would see that also in the bail and bond policy guidelines, as well as the sentencing policy guidelines of the judiciary. Secondly, the use of this tool is not unguided for the reason that in accordance, not in accordance, but in reference to the point that was made about automated judicial decision-making or automated decision-making, it is actually not making decisions. The decision ultimately lies with the magistrate, which is why they are the ones who give the sentence. It is only an assessment tool. There is a difference, an important difference, because it needs to be considered that the decision ultimately was with the magistrate. So they cannot just say it assessed the person, therefore it is as if it is the one that gave the sentence. That's not accurate. And finally, I shall be explaining to the court that the lack of a disclosed internal logic and methodology is actually quite irrelevant, because this system, just like other artificial intelligence systems, so I shall be getting a bit technical on the technology, a bit of psychology, a bit of philosophy, because it's about human thinking. So when you think about this system, think about human thinking. How do humans think? So it is trained on human models or human thinking models. It comes up with things we call predictive models, and so it is able to give accurate outcomes, as accurate as the moderated aggregate of what many magistrates and judicial officers would give. So in fact, this system is much more moderate and much more informed than what a single judge would do, because a single judge or magistrate would have their extremes. So this one is, I would say, in the middle point. So it gives actually the accused person an advantage. And then Hafsa shall come in and talk about the data-centric issues in relation to the NBIS, which would be, as we have listed in our memorials, issues B, C, and issues F. And then we shall be stating, and I think we can just state it now, that the reliefs are not merited. And Hafsa shall be showing that there was no violation of any law in the use of the NBIS for the reasons that, number one, there are already sufficient data security practices that have been enabled by the government, and we see that in the National Digital Master Plan. And these security practices are part of also the country's national rolled out a data system, data systems are used everywhere, and so there is sufficient, and there are sufficient already data security practices. Secondly, in regards to the DPIA, as we'll see in the case of Haki na Sheria versus Attorney General, and for purposes of reference being guided by the Honorable Court, you would see that in our list of authorities, that would be case law number 2 for the full reference, where the court lifted conservatory orders to enable the government roll out digital cards, because the public interest of allowing the government to execute its mandate was more important than halting the initiative just because a DPIA had not been completed. Now that is important here because a DPIA is underway and it shows the government's good faith. So the government needs to be enabled to execute its mandate in order with, or in accordance with its agenda and what it wants to achieve for the country. And the actually benefits, and provided the data is safe, then there should be no worry on the part of the appellant. In regards to the issue of consent, we shall be arguing that in regards to government operations, consent as compared with how private entities would be assessed, and it's good that the case of Republic versus Tools of Humanity Cooperation was raised, that case was about a private entity. This is the government. The government has certain exceptions, has certain room to play with in regards to data assessment practices. So you would see that in, for example, section 28(2)(f) of the Data Protection Act, which talks about indirect processing for purposes of prosecution, which was an example here. And at the same time, there is the duty to notify. And it is not true, if you look at the facts of the case, as if that the appellant was not aware of the use of these systems. They were aware. And so with these government operations on one limb and the notification and the true knowledge of what was transpiring by the appellant, they cannot say that consent was mandatory. Private entities or governments are not treated the same way when it comes to data. And so that will be our way of showing in regards to the issue of ultra-vires and the allegation about contempt of court, that the exception of public interest, as you'll see in the facts of the case, that is the NBIA's case. You look at Order C, maintenance of the system for essential public interest functions, that was within that, and Hafsa shall be explaining that. But before going into that, I would want to make some preliminary points, sorry. The question about whether this is a review or an appeal, from what we have in the facts of the case, it states that just before the reliefs, Patrick has now appealed. We take this as an appeal, and we urge the court to take it as such. If it is supposed to be a judicial review, then they should file a judicial review. But as far as we are concerned, we shall be treating it as an appeal. Secondly, there is a preliminary objection which we had given, as you see in our memorials. We would wish to withdraw it for the reason of public opinion. That is, we would think about what will people think if they say that the government only won on a point of preliminary objection. This issue of data protection and the rights of the appellant is a very heavy issue, a very weighty issue. So we have opted to confront the issues directly without engaging in procedural maneuvers. We are competent in what we have in the defense of the respondent and would wish to address the issues as they are. Now, I wish to delve into issues D and E, which, as I said, I shall be addressing, on the alleged violations of Articles 27 and Articles 50, as well as the alleged violations of Articles 47 and 28 of the Constitution. And I say as follows. Number one, and I would, in fact, let me just state so that I can be clear, I would wish to tackle these issues together for the reasons that they are related. So the arguments that I shall be making will be an answer to each of the arguments for the reasons that, if you look at the issue of due process in issue D, it is related to fair administrative action in issue E. Article 50 on fair trial is equally related to fair administrative action in regards to Article 47. Discrimination as set out, or the points on discrimination as we have in Articles 27 subarticle 1 and 27 subarticle 2 of the Constitution, about the equality of law and the full enjoyment of rights, they are also related. So whatever is applicable, or whatever argument is applicable to issue D is also applicable to issue E. But I shall be making it clear, I shall delineate my arguments clearly so that the court can be well guided on how I am answering and what exactly I am answering. So my first argument, in order to prove that there was no violation of Articles 27 Articles 50 and Articles 47 of the Constitution is that, as I had stated in the introduction, the assessment criteria that we have that are being used by the KRT are already today, even without the KRT, being used by magistrates in their decision making as well as judges. That is why I had indicated when we have probation reports and even mitigation by the accused, there is the consideration of where they come from and what their circumstances are. And when we look at, for example, the Criminal Procedure Code, in the assessment of bail, there is the consideration of, for example, whether someone would be a flight risk. So this shows that the circumstances of all people, whether rich, whether poor, are usually assessed before such a decision is reached, because these circumstances have an impact on the probability of someone complying with what the court would want them to comply with. And so in saying that looking at socioeconomic factors is discriminatory, it simply cannot be true. So, in short, the first point is that these assessment criteria are already set out in the Criminal Procedure Code, the bail and bond policy guidelines, and the sentencing policy guidelines. They have not come with the KRT. They have always been there. There is nothing discriminatory about them, and therefore we cannot say there is any violation of fair administrative action or of fair trial. The only difference is that now this assessment tool is automated, but in normal terms or in normal times, it is the judge who would calculate or who would think of the probability of recidivism. And to just give an example is how in Swahili it is said, ili iwe funzo kwako. That means so that it can be a lesson to you, so that you don't do it again, so that other people don't do what you are doing. So it is known that it is important to look at what is the probability of this person committing this crime again. And so this is just an automation. So the assessment criteria are not discriminatory and are not unfair in any way. Every person would be assessed based on their own merits. So there is no violation of Article 27, 50, or 47 on that limb of argument. Number two, and now I would go into the merits of this technology and how it works to prove that it is not violative of any of these articles. The first thing, as I had indicated in our introduction, is that it is not a decision-making tool. It is an assessment tool. The decision is the sentence. This tool only assesses the probability of recidivism. So once it assesses, this value is considered independently by the magistrate, and they will be guided as to, okay, so this tool has told me that this is the probability of this person committing the crime yet again. And as a matter of fact, we have seen that Mr. Patrick Osogo is a repeat offender. And therefore, with that in mind, and with the consideration of other factors such as mitigating factors, such as the probation officer's report, then the judge or magistrate is able to make a more informed judgment. So the decision does not lie with this system, it lies with the magistrate. Now that takes me to my second point in regard to how this technology works and how it is not violative of any of these articles. This tool is an artificial intelligence tool, meaning that it is trained using models of human thinking. So whatever magistrates and judges would think, it has been trained to think in that way. So, in essence, its reasoning is the same as the reasoning of a judge or a magistrate, but now with the added advantage that it has been trained on thousands or hundreds of thousands of data sets, which would, for example, include cases, judgments, and then it is able to note the patterns and consistencies. Once it knows the patterns and consistencies, it comes up with what is called a predictive model. So it is able to predict. But now, this prediction is not binding. Remember, it is an assessment. So after this, then it is able to give a quite informed quantitative. Now we move from qualitative, that is the assessment of judgments or the reasoning of human beings, and then it forms a quantitative value. This quantitative value then becomes the probability, based on how it has noted judges and magistrates' reason, the probability of this person becoming a recidivist. And this is also in addition to the other factors that are usually considered by judges and magistrates, which would be the factors such as the socioeconomic factors. So to just cut down the jargon, what we are saying is this. This system reasons just like human beings. Now, so it is known how it reasons. What is not known, And this is now where I was talking about it getting a bit technological, a bit psychological, a bit philosophical, is how it achieves that reasoning. How is it able to aggregate all these values? So that is what we don't know. Now, that would sound bad, but when you think psychology, and now let us talk about human psychology, we have the conscious mind and the subconscious mind, because we must consider that this system thinks just like human beings, so that we can show you there's nothing unfair about it. We, as human beings, do not even understand our own subconscious mind. That is why it is called subconscious. So if you look at logic and methodology, it is different from internal logic and methodology. So internal logic and methodology would be as if we are questioning the thinking of someone's subconscious mind. But that is not a competent question to ask, because it is also not a question that is asked to human beings. So in short, what we are saying is this. This system is trained based on human thinking. It is trained not only on human thinking, but thousands of data sets of human thinking, which means it would give the same result as the aggregated result of many judges and magistrates, and it is therefore more informed. And as a matter of fact, as I had stated, it is moderated. So in fact, it helps in giving a more neutral judgment. Because there is a judge who would give 7 years, another would give 3. But this system enables the assessment of many considerations of what many judges and magistrates would have thought, and it gives a standard value. So when the magistrates or the magistrate considers this value, they are essentially moderating themselves. Instead of trying to think, what do I personally think is the probability of this, this person becoming a recidivist, the judge of magistrates uses this system. So it is the same way as using a calculator. It is much easier, the probability of error is less, and because it eliminates the subconscious biases of the individual judge or magistrates, it is in fact more neutral. So in short, what we are saying is this. In the same way that the subconscious thinking of a human being or of a judge is not questioned, then it is also irrelevant to question the sort of subconscious mind of this machine. What matters is that we know, as a matter of fact, it thinks the same way human beings think. And the advantage, on top of neutrality and moderation, as I said, is that it takes less time. So that instead of a magistrate or judge beating their mind trying to think what's the probability, they're able to use a tool that is able to make the decision or the assessment much faster, and therefore it improves the service delivery, as we said, because this is one of the reasons we are using this system. It improves the service delivery by cutting down the time needed for judicial considerations to be made. We know there's a lot of backlog of cases, so this system, and we shall prove it over the years, criminal cases will in fact be cut down in terms of the time they use. So this is as part of our effort to reduce the time that cases take in order to be determined, because that has always been a problem in this country. And finally, so in that regard, honorable judges, again, with the human-centric and the human thinking aspects of this system, there cannot be said to be any violation of any fairness in accordance with Article 47 or Article 50, or even discrimination. Because to say that this system is discriminatory or is unfair would be like saying judges and magistrates themselves are unfair, because it is trained exactly to think the way judges and magistrates think. So we might as well just eliminate the whole criminal branch of law, because apparently there is unfairness and discrimination in the entirety of it. Allow me to conclude with Article 28. Now, Article 28, which is in issue E, and I have handled it separately because it is unique and it is a bit separate from these other issues. It is not directly about fairness or it's not about procedure as such. It is more of a substantive personal right about humanity and what human beings feel. Would like to direct the court to the case we have cited, again in our list of authorities, case number F, Dongo T.A. Mwandunga Commercial Agencies versus KCB Bank Limited. And in that case, Mr. Ndongo was telling the court, or was claiming, that KCB had defamed him for giving his information about his default rates to the credit reference bureaus. So he was saying KCB is indignifying me by telling the credit reference bureaus that I don't pay my debts, which of course, if you have a poor credit score, you are not able to get loans, and it will affect your lifestyle, it might affect your business because you don't have any money and nobody wants to loan you money. But the court stated, no, that is not true. The truth is that, in fact, you do not pay your debts. In fact, it is just true. It is simply true. So you cannot say that you are being indignified about or by something which you yourself did. The ball is in your court. If you simply pay your debts, you have a good credit score, and in fact, KCB and all banks, they are mandated by law to give this information to credit reference bureaus, then there will be no problem. You'll have a good credit score, and you are not going to claim to be famed or defamed. So this is simply a neutral issue. Now I conclude with making that very same point about Mr. Patrick here, the appellant. He is a recidivist. As a matter of fact, he is a repeat offender. As a matter of fact, he has his background. As a matter of fact, he has not shown any indication or any need to change. It is as if he has decided that this will be his lifestyle. And perhaps that is why he has kept repeating these offenses. Community, then how is that indignifying to him, yet it is his own actions? Is it a lie that is being told about him that he keeps repeating offenses? It is not a lie. And that is why I go back again to the aspect of discrimination. If these are standards that are being applied to everyone, and everyone is assessed based on their own merits of, and character being also something that is considered in evidence law, then there is no way in which it can be dignifying. And I would conclude by saying, if saying that someone is a repeat offender would be dignifying, again, we would rather then eliminate criminal law as a branch of law altogether, because when people go to jail, then they are sort of set aside from the community, and they are known to not have a good reputation. And for those many reasons, that is why we say there have been no constitutional violations in regard to the criminal process, and therefore the reliefs are unmerited. Unless there are any questions from the bench, honorable judges, I wish to cede the floor to Hafsa.
Counsel, thank you for some very good arguments. Certainly, the court will make some observations. So my fellow judges.
Thank you, Presiding Judge. Counsel,
yes,
you made references to a number of already existing laws and guidelines,
yes,
that would be equated to the KRAT. You have also recognized KRAT as a tool that uses AI and AI systems in terms of how it operates. So my question, and what I'd like to hear from you more, is what then is the position of, in as much as the existing policy, this system as regards the requirements of the Data Protection Act as far as automated decision making is concerned? And specifically, I'd like to hear from you more on the issue of the need for human intervention, information on logic, as far as the Data Protection Act is concerned.
To answer that question, I would cite section 30, I believe it is, I hope 35 subsection 2 paragraph B. I don't think it is 32.5B, I think it is 35.2B, which talks about automated decision making. That where a decision is going to be made by a system such as this, without human intervention, no, let me talk about 35 generally, then the exception, because that 2 is an exception. So generally, automated decision making is not something that is well regarded by the Data Protection Act. That is why I think there was talk of profiling. So it is true, we are aware of this. But 35.2B has an exception that if automated decision making, and again, we do not agree that this is automated decision making. We think it is assessment, which is separate, because assessment is not a decision. It is only a probability calculation. So as long as, but in any case, if worst would come to worst, and it is this system which would be making the decision, provided that it is for a public operation and sufficient data security practices have been put in place, and there is a need for the use of this system, there is no problem. And it is in fact an alternative to consent. That is why at the beginning I said that provided there are adequate data security practices and the person has been notified, then it is an alternative to consent, because the essence of this is accountability. So provided there is accountability, there will be no problem. and especially the consideration of a public operation.
I think my question was similar to my sister here. Thank you, Council.
Now, Council, I have one. You have raised a preliminary objection.
We have withdrawn.
Sorry?
We withdrew.
You
it.
withdrew the preliminary objection?
Yes, we'd prefer to just confront the issue so that the public does not say we are running away from answering questions.
Okay. Thank you. Okay. Now we can go to the next part of and that is your core counsel. Welcome. You don't need to swear. I've seen you holding something. So you are an officer of this court. Feel free, and we are ready to hear your argument. Thank you.
Thank you, Co-Counsel. May it please this Honorable Court, as introduced, my name is Hafsa Yusuf, second counsel for the respondents. I'll be handling the data-centric issues, that is issue A, B, and E. In regards to issue A, that is whether the processing of the appellant's personal and biometric data, whether the processing of the appellant's personal and biometric data violated Article 31 of the Constitution and Sections 25, 31, and 41 of the Data Protection Act due to there not being a DPIA, we submit the following. It is our respectful submission, honorable judges, that in maintaining the NBIS, the respondents acted within the High Court's express allowance for continuation for essential public interest functions pending a DPIA. Public interest under Kenyan law concerns matters which the society at large has at stake. The government's objective of digitizing government services to enhance efficiency in service delivery falls within this threshold. We refer to the case Maisha number case, which in our case law, as guided by the Honorable Court, case number 2, Haki na Sheria Initiative versus Attorney General, the High Court lifted conservatory orders to allow the Ministry of Interior to proceed with issuing national IDs pending a DPIA. Similarly, in the Huduma number case, that is Nubian Rights Forum versus Attorney General, in the case law is issue G, that's issue 7. Apologies, case number 7, Nubian Rights Forum versus Attorney General. The court did not simply halt the system. Rather, it identified specific gaps to be addressed before full rollout. What emerges from both these decisions is clear, that the courts consistently declined to halt these public systems simply because compliance was ongoing. Hence, we seek to show that it is not a foregone conclusion that there are contraventions of the Constitution and the Data Protection Act simply because a DPIA is pending. Honorable members of the bench, we do acknowledge that the earlier rollout of NBIS was unlawful, but circumstances have now changed. There is a DPIA that is currently underway. No new data has been collected by the government, which is a sign of good faith and gradual compliance, which this court has already recognized in the Maisha number case, that is Haki na Sheria Initiative versus Attorney General. And lastly, in regards to this issue, honorable judges, the data that was collected was not new. Rather, it mirrors data that has already been collected under other civil registration regimes, as my co-counsel stated in our opening statement. This very data is also protected by the wider national security infrastructure and also data privacy by design and default, which aligns with Section 41 of the Data Protection Act and also aligns with the objectives of the National Digital Master Plan 2022-2032. I end my submissions in regard to that issue and wish to proceed to the next issue. That is issue, whether the use of the data derived from the NBIS database in the operation of KRAT without the appellant's knowledge or consent amounts to unlawful data processing and an infringement to the right of privacy of the appellant. We submit the following. But before I submit my issue, honorable judges, allow me to direct you to several sections of the Data Protection Act, which I do acknowledge we did not submit in our memorials, but kindly allow us to direct you for purposes of mentioning the law. Section 28, Section 20.
Council, you have made an application for us to allow. So let me consult and then I'll give you a short ruling.
Much obliged, Your Honor. Much obliged, my lord. Apologies.
Yeah, it's okay. Around? Your application is around. Please proceed.
Thank you, honorable judges of the bench. Allow me to direct you to section 28, subsection 2. F, Roman 1, which talks about indirect processing of data for the purposes of prosecution and punishment of crime, as my co-counsel had earlier mentioned. Additionally, section 30, subsection 1B, Roman 1, which talks about the collection of data which can be done without consent if the processing is necessary for exercise by any person in public interest and function of public nature. Honorable judges, this tool was used in helping judicial officers to make bail and sentencing decisions, which number one is a public function because it is carried out by the judiciary, which is under the government, and it also aids in the function of prosecution and punishment of crime. In addition to that, Your Honor, there is the duty to notify, which we submit to this honorable court. The respondents did uphold that duty. In regards to the NBIS instance, before the full rollout of NBIS, we see that the government had published a national digital master plan which talked about digitizing these government services for efficiency for the citizens to access these public services easily. Additionally, we submit to this honorable court that the government uses public mass communication system to inform citizens of national programs, for example, televisions, newspapers, and radios. In regards to the KRAT, honorable judges, we do submit that the appellant did know of the use of this algorithm tool during the case from the bail decision to the sentencing decision. Hence, there was the duty to notify, which was upheld. So, apologies, the duty to notify was upheld. Honorable judges of the court, allow me to pose a question to you. When the appellant presented himself for registration, was he truly completely unaware for the reason or for the purpose of this data collection? With respect to this court, we submit that that sounds unrealistic and even amounts to hyperbole. Additionally, the appellant's argument that the government had to individually seek consent from each citizen in a country full of millions of citizens sounds impractical, honorable judges. Lastly, we submit to this honorable court that it defies logic that the appellant did not know of the use of this data, given that this data is the same data that is normally submitted when you're accessing government services, such as getting a national ID card, getting your driver's license, passport, and also a KRA PIN. Lastly, my lord and my ladies, in regards to my last issue, that is whether the respondents' continued reliance on the NBIS database for algorithmic processing and interoperability purposes was in contempt of court and ultra-vires action. My lord, my ladies, we seek to substantially rely on the submissions we have made under issue B, since these matters are closely linked, and it is our position that the respondents still acted within the High Court's express allowance and cannot be said to be in contempt of court or ultra vires. I end my submissions at this point. I wish to yield the floor to the bench. Thank you.
Okay, thank you. It's okay, we will have some questions.
Thank you, Presiding Judge. Counsel, from the facts of the case, the summary of facts, the purpose of the National Biometric Identification System was for the identification and verification of Kenyan citizens, and it's later clarified that NBIS would enhance national security, reduce fraud, and facilitate digital access to essential public services. So which of these purposes would you say the KRAT system falls, one? And please clarify how it falls, which purposes it falls under, and how it falls under that purpose.
Much obliged, my lady. I wish to pardon on the options that you have given, which NBIS functions in. Just the options, kindly, my lady.
The options are in the fact sheet that the ministry launched the NBIS as a centralized database to serve as a single source of truth for identification and verification of Kenyan citizens and residents. And it was justified on the grounds that NBIS would enhance national security, reduce fraud, and facilitate digital access to essential public services. So what I'd like to hear from you, Counsel, is which of these purposes does KRAT fall and how?
Much obliged, my lady. We submit to this honorable court that the KRAT falls under the facilitation of digital access to essential public services. I will give an example. The e-filing system came about because there was backlog in cases in the judiciary, whereby lawyers had to come in physically, submit these cases, hence giving the workers under the judiciary a lot of work, hence the backlog occurred. Honorable judges, the KRAT, in this instance, as my co-counsel had mentioned earlier, helps the judicial officers, that is the judges and the magistrates, to assess the case in point and the probability of the defendants in the cases that they are working on, so that they can work on other aspects of the case instead of batting around the probability of this individual. Will he do this again? Will he not do this again? So that it removes the stress of thinking about that aspect of a case, my lady.
Okay, so in this case, then the collection was to facilitate digital access to essential public services by the magistrates' court. And is it by the magistrates' court or by the appellant?
My lady, I submit to this honorable court that in addition to what you mentioned earlier right now, that they, also in alignment with the National Digital Master Plan, is to enhance efficiency of service delivery to citizens of this country.
Extensively mentioned. Now, you did state that it's a project that is used to automate critical government services. Now, does this service take away the right of consent to any other government, to all government services? Is that your submission?
Honorable, my lady, in that regard, I wish to submit that no, it does not take the right of consent away, especially from the data subject. But in this regard, in our submissions, Your Honor, And as my co-counsel stated earlier, that we are the government, we are not a private entity. So the methods and the modes which a private entity would use to get consent isn't the same as the way the government would get consent. As I had mentioned in my submissions earlier, that the government, before the rollout of NBIS, had, number one, published this National Digital Master Plan to inform citizens of what this automation or what basically the National Digital Master Plan is mainly about improving the digital economy of this country. And among one of the points being under it is automation of government services for efficient service delivery. So that being under the objectives, and also, apologies, Your Honor, apologies, my lady, we also used public mass communication systems to inform the citizens of what this system is about, so that when they are coming for registration, they know what's happening, and so it is a clear affirmative consent, because they already know what the system is about, and they have presented themselves to come and willingly give out their data, my lady. I hope that suffices as my answer.
Counsel, thank you for some very able arguments and also some good time management. Okay, I think we will now go to the next stage. Yeah, this is the stage of the debatters.
Thank you, my lord. Thank you, my ladies.
Okay.
Honorable members of the bench, it is again an honor to appear before this honorable bench. In the issues that the respondent has raised, I'll begin with answering the issue on jurisdiction, on the issue of whether this is an appeal or a review. Honorable members of the bench, we acknowledge that jurisdiction is everything, and without it, a court cannot make a step into a proceeding. Honorable members of the bench, I am guided by Section 9(1) of the Fair Administrative Act, which states that an aggrieved party, that is when a party is unaggrieved by a decision of a public body or a trial court, it may appeal or bring that matter for review by the High Court. Honorable members of the bench, I am further guided by Section 11 of the Fair Administrative Act, which among the remedies provides a remedy of certiorari which honorable members of the bench states that the High Court may give an order of certiorari in remedy of the process aggrieved if it finds it proved. And on these honorable members of the bench, I rely on the prayers that the petitioner has brought before this honorable court, one being an order of certiorari, quashing the decisions of the trial court. Now that is a decision that falls under judicial review and a remedy that only this honorable court can grant. On the second issue that was raised by my counsel here, on KRAT being an automated decision-making tool. Honorable members of the bench, I rely on paragraph 8 of the fact sheet, where it's illustrated that KRAT was a tool that was used for profiling to decide whether this person is a high-risk or a low-risk person, and this entire decision was fully automated. It was not an interaction between the magistrate and the KRAT, where the KRAT says, according to me, I think that this person did not even finish their high school education, thus they are a high risk. No, it made the decision fully, it was made decision by the KRAT system. Thirdly, Council has raised an issue on whether the Data Protection Act, Regulation 31, applies to public bodies or private bodies. This raises an issue of rule of law, and we acknowledge that no one is above the law. And Section 30 of the Data Protection Act does not mandate that this only applies to private bodies, not public bodies. Consent is a prerequisite that applies to any data controller or data processor. The NBIS being a system, seeing that my time is up, I request for the mercy of this honorable court. Just 1 more minute.
It's okay, you'll have a minute.
And it does not say that it applies to public bodies, not private bodies. It is a prerequisite for any data controller or processor. I think that will be all, honorable members of the bench.
Okay, thank you.
Just one question, presiding judge, thank you.
Yes, ma'am.
Is consent the only lawful basis for processing, or are there any other lawful basis for processing personal data that can be relied on by public bodies?
Thank you, my lady. On answering that question, I rely on the arrangement of grounds given under Section 30, section 30. And consent is the first, it's subsection A. And in my understanding, the drafters of the Data Protection Act intended that consent will be the first ground to be considered. In the present matter, Mr. Patrick Osogo is readily available. He was the NBIS system could reach him. They had access to. His consent was readily available to be acquired. They should have made a step to gain his consent, and if that was not possible at all, then proceed to consider the other grounds.
No other questions. I think the respondent will take.
Thank you,
You are
Honorable.
about to now. Yeah, thank you.
I will just say
Now,
Thank
yeah,
you.
you have 3 minutes to make your rebuttal.
Thank you, Mr. Presiding Judge. The first thing I would want to say in regards to the point that had been made about automated judicial decision-making, and we have been drawn to paragraph 8. I would say second paragraph from bottom in the background. I find it difficult to count because they are not numbered, but it states that KRAT is an algorithmic risk assessment system designed to assist, not to make the decision, to assist. So let the court take note of that. I shall not belabor it. That shows that it is not the one that actually makes the decision. The second point about consent, that it still has to be derived in a direct way, like the way a company like Facebook would, it is not correct. If you look at sections 30, there are actually quite a number of sections, sections 30, 32, 35. In the provisions about consent, they are disjunctive. So you are going to see in those paragraphs, of course I would not know them verbatim, but you are going to see it is going to give a provision about public operations, for example, and then another provision, and then it's going to say or. So that goes to our point about the combination of the essential or the difference in the nature of how government are accorded their duties in the Data Protection Act versus private companies. Private companies have to get consent, although there are also exceptions such as where there is a contract, but in this case, the point is or. So it is not that there is shown a public operation and a duty to notify and consent. It is public operations and duty to notify or consent. So it is disjunctive. So whatever they have said that consent must be derived in a direct way for all entities, government and private, is not correct. And finally, there was a
So the directions of the court, are that we will give our general comments. And then after that, we will adjourn. And then we can release counsel, your clients, and also the audience. This is a public hearing, and then we will give further directions later. Okay, thank you. Okay, thank you. So we will start with general comments.
Okay, thank you, presiding. Good job. You've done very well in terms of your court etiquette and maintaining eye contact with the judges. That was quite commendable. As well as the flow of thought and analysis. We've seen very good analytical of the bar. Great job on that. The only thing maybe I'd also wish to add is further research on especially the data protection law, regulations, the principles, and how they apply to the facts. It would be great to hear more specifically on that. How do the principles, how does the Data Protection Act apply to specific issues raised in your arguments? It would have been good to hear more on the principles, the laws, the requirements, obligations, rights, etc.
Judge, for me, I'm very impressed. Well done. I like you are all done. I like you are all very confident, and you did not read from your mind, which is very impressive and commendable. And just one or two things that maybe you need to work on is that when you're quotes law, remember this is a matter that has come from the lower court. Remember this is a matter that has come from the lower court to the high court, and you know the hierarchy of the hierarchy of. It's always good, even as you're quoting. Make sure you mention is a Court of Appeal decision, this is a Supreme Court decision, this is a High Court decision, because of the persuasiveness and whether it's binding, whether it's binding or it's just persuasive, yeah. Then the other issue, maybe you given an opportunity to rebuttal. Remember, rebuttal, you cannot introduce new facts. Stick if you can to the law, which is important, because your opponent will not get another opportunity. And lastly, as maybe mentioned by my colleague, but I want to emphasize on this is the data protection beyond the act.
Okay. Bailiffs, you can stand. So as they stand, allow me to take this time to request, as ladies and gentlemen, to appreciate our judges for the wisdom and sitting through with us and guiding us through the final rounds of this particular session. Thank you. So the finalists. We'll start with the appellants. So we can just take that was being used by the bailiffs, both the appellant and the respondents, both teams. So we welcome fellow participants and members who are open to having a group photo with the rest of the team, so they can just join us. Let us give some space to our finalists so the rest come and join. Yes, so that we only have the finalists at the top. Just come here. So. Thank you so much. So we may resume our seats. So at this point, ladies and gentlemen, release our judges. So for the rest of us, let us stay behind for the next communication on what will follow from here. Thank you. So as our judges wind up, there's a polite request for another round of photo sessions where we took Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome
to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Here in Mombasa, where cultures converge and ideas flow, leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. Guided by the Office of the Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development. The future belongs to those who trust their data and those who can be trusted with data. Welcome to the Data Privacy Conference 2026. Trust the data, drive the future. Everything begins with trust. In a world driven by data, trust is the foundation of innovation. From healthcare to finance, from government to the everyday digital journey, data shapes decisions that move nations forward. But as technology evolves, so do the risks. Breaches, misuse, and misinformation. Threats that can erode public confidence. To drive the future, we must first protect the present. Leaders, innovators, regulators, and advocates unite. Together, we shape Africa's digital future. The Data Protection Commissioner, Kenya continues to build a trusted data ecosystem, one that protects rights, fuels innovation, and accelerates national development.
of the first National Data Protection Moot Court Competition 2026. And this is what all of us have been waiting for. So at this particular point in time, I'll be welcoming you to the awards session. So our awards session is twofold. We'll first of all appreciate the people who stood out. And under this, we'll be having special awards under the following categories as communicated during the start of this particular competition. So we'll be having an award for the best written memorial. We'll also be having an award for the best oralist. We'll be having an award for the second runners-up, the first runners-up, and now the winner's award is special. Special in the sense that it is partial. The first bit will be handled today, with the second one being handled later on in the month during the annual Data Privacy Day. The second category of our award session, ladies and gentlemen, will be appreciation for all the teams that made it to the quarterfinal rounds. So under this, we'll be calling representatives from each of the institutions to be able to collect their certificates. And I'll now go straight to the award session. So to start us off will be the best written memorial. This award will be presented by Judge Bridget Ndong. And ladies and gentlemen, the best written memorial for the first Data Protection Moot Court Competition 2026 goes to the University of Nairobi. So, as we keep appreciating them, we'll be calling the representatives to come and pick this particular award. So let's keep clapping. So I'll request Judge Ndong to still stay behind to present the award for the best oralist. So ladies and gentlemen, the best oralist for the first National Data Protection Moot Competition 2026 is Mr. Jeremy Gisheru from Kabarak University. Congratulations, Jeremy. Thank you, Judge Ndong. So for the next 3 categories of awards, I would request the Deputy Data Commissioner, Corporate Services, CPA Festus Musyoki, to grace this particular category. And ladies and gentlemen, to start us off is the second runners-up category. So the second runners-up for the first National Data Protection Moot Court Competition 2026 is the Umma University School of Law and Sharia. Let's keep appreciating them as they receive their award. Thank you. Ladies and gentlemen, are we ready to appreciate our first runners-up? At this point in time, allow me to welcome our first runners-up for the first National Data Protection Moot Court Competition 2026. Are you ready? Ladies and gentlemen, give it up to Riara Law School. Let's keep appreciating our first runners-up as they get makofi kwao tafadhali. Congratulations, Riara Law School, the first runners-up for the first National Data Protection Moot Court Competition 2026. And finally, to announce the winners of the first National Data Protection Moot Court Competition 2026. Ladies and gentlemen, give it up to Kenyatta University School of Law. As they receive their gift, allow me to mention that this unique category attracts not only what you can see being presented over there, but also 3 paid internship opportunities whose details will be communicated, in addition to a special recognition at the annual Data Privacy Day 2026 in Mombasa. I would kindly request you to once again appreciate our winners. Thank you so much to Bwana DDC for appreciating them. Now, our second category of awards is appreciations to all the teams that made it to the quarterfinal rounds of the first National Data Protection Moot Court competition 2026. And this category will be rewarded by Miss Peggy Mwai from MMP. Makofi kwake aki. So remember, as she makes her way to the podium, each institution will be required to nominate a representative to collect their certificates of participation. So without any order of priority, I would like to invite the representative from Embu University School of Law to collect their certificates of appreciation. Makofi kwao. Thank you so much, Embu, for gracing the inaugural National Data Protection Moot Court competition. And we hope to see you again in the subsequent competitions. After that, I would request a representative from Riara School of Law to pick their certificates of participation. Remember, Riara School of Law double up as the first runners-up for this particular edition of the competition, and we congratulate you and hope to see you again in the subsequent editions. Next, we'll be requesting for a representative from the Egerton School of Law. Makofi, makofi. Egerton, it was a pleasure having you around, and we hope to see you in the subsequent editions of this competition. Next in line is Strathmore School of Law. Thank you, Strathmore, for being part of the inaugural edition of this Moot Court, and we hope to see you again in the subsequent editions of this. Next in line, ladies and gentlemen, is the Umma University School of Law and Sharia. Remember, these are our second runners-up for this particular inaugural edition. It was nice having you, Umma, and we hope to still see you around in the subsequent editions. Thank you. Next, we have Kenyatta University School of Law. Who are the winners of the first National Data Protection Moot Court competition. Congratulations once again to you, Kenyatta University, and we hope to see you in the subsequent rounds. Next, we have Kenyatta University Lex Machina. I hope I pronounced it right. We kindly request their representative to come and receive their certificates of participation during this edition. Okay. As they make their way here, let us keep on appreciating them. Thank you. Thank you for the formidable fight. Kenyatta University Lex Machina, and we hope to see you and host you in the subsequent editions of this. And last but not least, Kabarak University School of Law. We kindly request the representative to make their way to the podium. Kabarak, thank you for the spirited fight, and we hope to see you in the subsequent editions of this particular edition. Makofi. Thank you so much, Peggy, for gracing this session of the awards. So with that, ladies and gentlemen, we come to the end of the awards session. And without further ado, I would like to welcome the Director of Legal at the Office of the Data Protection Commissioner, Ms. Susan Waweru, to give the vote of thanks. Thank you.
Good afternoon, ladies and gentlemen. Once again, I would like to congratulate all the winning teams and wish you the best in your future endeavors. Congratulations. First of all, I would like to thank God, obviously, for making this possible. We've had a hitchless event, no accidents, health incidences. We've had peace throughout. We've not had protests. We thank God for that. The Data Commissioner, who is the head of our institution, I would like to give thanks to her for making this possible, availing, backing us up, trusting us with this process, buying into our vision to impact the youth and have a data protection-centered law schools, and we want to thank her for that. We want to thank the judiciary, specifically the Chief Justice and the Registrar of the Supreme Court, for offering us their venue and facilitating us with judges and just their overall support. They've offered protocol services, security, and allowed us to reign free without any hitches. We thank them for that. The judges of the Moot Court, those present and those not here with us, we want to thank them for their objectivity, their tenacity. They really put you to task as we were roaming the rooms, and we want to thank them for that, even for availing their time and their expertise to us. The planning committee, the ODPC planning committee, want to thank them for the last 3 months, rallying this up together, conceptualizing this and crystallizing it today with this penultimate event. The institutions present, all the universities who sent their students, coaches, we want to thank all those who have participated in this inaugural data protection moot court. We thank the institutions as well. The teams and the coaches, well done. That was a good effort. You gave us a run for our money. The bar has been set high. Your memorials and your presentations were really, really hard to judge because they were good. So this is my affirmation to you that you have done a good job, all of you. Somebody had to win, but I'm here affirming you that we read every one of your memorials, we listened to your presentations. Well done. To the bailiffs, the ushers, all those who made this event seamless, to the timekeepers, to all the providers, we want to thank you. To the MC and the moot coordinator, Eugene and Simon, thank you for your effortless work. And lastly, we want to thank also our partners, the service providers, those providing food, those providing the streaming services, every single person who had a hand in this. We want to say thank you. Once again, karibuni and see you next year.
Thank you so much, Ms. Susan Waweru. So before we head to wrap up this particular session, I would just take this opportunity to welcome the Deputy Data Commissioner, CPA Festus Musyoki, to just give closing remarks and appreciate us for staying in for all these particular hours. Thank you.
Thank you, Eugene, and I think I will not say much. Vote of thanks has been said. Good afternoon, ladies and gentlemen. How are you? I think it has been a very good good event, and we are happy to host this as ODPC, this being the inaugural, and we look forward to engaging with all of us in the subsequent editions. There are no losers. We are all winners. I know for those who maybe have not made it to the first, to be first, you have opportunity even in the future, and we look forward. I know you have learned lesson and the wisdom from that. So we wish you all the best, and on behalf of the ODPC, you enjoy the rest of your day, and we look forward even to seeing you during the Privacy Day, which is just around the corner. Thank you.
Thank you so much, Bwana DDC. So at this point, allow me to call upon Ms. June Silanoi to officially close the program with a word of prayer, so that now from there, everybody will be at will to live at their own pleasure. So, June. Yes, so in line with the spirit of our right to food, immediately June finalizes this prayer. I believe she'll be doing a twin prayer to thank God for keeping us this far and also bless our lunch. So thank you.
Praise the Lord. Praise the Lord again. And it's through him that he has enabled us to reach this day. And we have completed the competition successful. Let's all believe and pray. Heavenly Father, we thank you for this day. We thank you, Father, for enabling us to carry out this event successful. We thank you, Father, for the organizer, the ODPC management, for the committee, Father. As we depart, may God guide us. We pray for the food as we are going to eat. May you bless everything. I pray and I believe.
Thank you so much, June, and